was thank you, Your Worship. You are not doing this for yourself that is coming to this court. It is not about yourself, it is about justice. Yes, Your Worship. So leave everything to us and then go and write your exams and concentrate on your examination. Thank you, Your Worship. Good luck. Thank you, Your Worship. Close quotes. The matter was thereafter postponed to 22nd October 2018. On resumption, attorney for the applicants, Mr. Doberman, extensively addressed me about what occurred outside court after the matter was adjourned. In part, he stated the following, I quote, "In essence, I am instructed that accused number 2 and 3, as well as their family members who have been attending court and supporting them and other supporters are in fear for their lives should they approach the court. They have informed me that when they come to and leave court, they have been mobbed, and now I am referring to what transpired last week. Crowds of persons have been allowed to press up against them. They have been allowed to abuse them verbally, and they have been allowed to throw items at them, including water. Mrs. Omotoso, accused number 1's wife, was drenched in water the other day. I saw it myself. In an endeavor to resolve the situation, I myself approached the police here at court and asked them to take steps to guard against what is happening, close quotes. He specifically stated that he was placing the matter before court and did not seek any order. Pursuant to that, I made a comment and suggested that if necessary, criminal charges should be laid with the police and an interdict be sought. If required, I further gave an order that accused number 2 and 3 be escorted by the police when approaching and leaving the court precinct. Thereafter, Mr. Doberman brought an application for my recusal. A notice of motion coupled with the founding affidavit of the first applicant and the confirmatory affidavit of the second applicant. The latter read in part as follows. I share exactly this, quote, I share exactly the same sentiments as those expressed by him in paragraphs 11 to 14 thereof, close quotes. Paragraphs 11 to 14 of the founding affidavit read, I quote, my perception is that in making the comments highlighted in bold above, 1, the Honorable Presiding Judge has already made up his mind and found that Ms. Zondi has come to court to testify, not for herself, but as a member, as a crusader in a quest for justice. 2, the Honorable Presiding Judge is overtly sympathetic towards Ms. Zondi and her cause. 3, the Honorable Presiding Judge has openly identified and aligned himself with Ms. Zondi's cause. 4, the Honorable Presiding Judge has already decided that Ms. Zondi's version is true and accepted same without hearing all the evidence or argument. 5, the Honorable Presiding Judge has already decided to mete out justice on behalf of Ms. Zondi. 6, the Honorable Presiding Judge has already decided to convict and sentence me and the second applicant. 7, the Honorable Judge is biased in favor of Ms. Zondi and the prosecution. 8, the Honorable Judge is prejudiced against me and the second applicant. 9, the Presiding Judge is and will not be impartial. And 10, I and the second applicant will, in the circumstances, not receive a fair trial before the Honorable Judge. Paragraph 12, in my belief and respectful submission, the said comments by the Honorable Judge, Presiding Judge, presuppose an ultimate outcome favorable to Ms. Zondi and admit of no reasonable interpretation other than that which I have placed thereon. 13, in my respectful submission, the Honorable Presiding Judge has, unfortunately, and in the circumstances, disqualified himself from continuing to preside over the matter. 14, I seek only a fair trial before an impartial judge and justice. I do not make this application lightly. I know that my trial is likely to be delayed by the replacement of the presiding judge, and since I am in custody awaiting trial, that I will be prejudiced thereby, close quotes. Mr. Doberman also raised from the bar another complaint. He referred to what I said earlier on before the application for my recusal was brought. I shall revert to this later. The legal framework. In President of the Republic of South Africa versus South African Rugby Football Union, 1999, Volume 4, SA 147, it's a constitutional court decision. The court stated the following about the recusal of a presiding judge. I quote paragraph 45. From all the authorities to which we have been referred by counsel and which we have consulted, it appears that the test for apprehended bias is objective and that the onus of establishing it rests upon the applicant. The test for bias established by the Supreme Court of Appeals is substantially the same as the test adopted in Canada. For the past 2 decades, that approach is the one contained in a dissenting judgment by De Branch in Committee for Justice and Liberty et al. Versus National Energy Board, and the court quotes, the apprehension of bias must be a reasonable one, held by a reasonable and right-minded persons, applying themselves to the question and obtaining thereon the required information. The test is what would an informed person, viewing the matter realistically and practically, and having thought the matter through, conclude. In R versus RD in brackets, Corey J, after referring to that passage, pointed out that the test contains a twofold objective element. The person considering the alleged bias must be reasonable, and the apprehension of bias itself must also be reasonable in the circumstances of the case. The same consideration was mentioned by Lord Brown Wilson in Pinochet. Decisions in Canada, Australia, and New Zealand have either refused to apply the test in Rec versus Go, or modified it so to make the relevant test the question whether the events in question give rise to a reasonable apprehension or suspicion on the part of a fair-minded and informed member of the public that the judge was not partial. An unfounded or unreasonable apprehension concerning a judicial officer is not a justifiable basis for an application. The apprehension of a reasonable person must be assessed in the light of the true facts as they emerge at the hearing of the application. It follows that incorrect facts which were taken into account by an applicant must be ignored in applying the test, close quotes. It is therefore trite that the test for apprehension of bias on the part of the judicial officer is objective and the onus is on the applicant to establish it. The test is whether the reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge would not be impartial. It is also trite that what is required of a judge is judicial impartiality and not complete neutrality. It has been stated eloquently by the Supreme Court of Appeal in State versus Schockel, 2001, Volume 4, SA, page 1, SCA, at paragraph 22. I quote, "It is accepted that judges are human and they bring their life experiences to the bench. They are not expected to divorce themselves from these experiences and to become judicial stereotypes. What judges are required to be is impartial. That is, to approach the matter with a mind open to persuasion by the evidence and the submissions of counsel," close quotes. There is a presumption of impartiality which is placed on judicial officers. Judges, including myself, regard this presumption of impartiality in a serious light at all times. In Bennett versus Absa Bank Limited, Ngobo CJ articulated the presumption thus: what must be stressed here is that which this court has stressed before, the presumption of impartiality and the double requirement of reasonableness. The presumption of impartiality is implicit, if not explicit, in the office of a judicial officer. This presumption must be understood in the context of the oath of office that judicial officers are required to take, as well as the nature of the judicial function. Judicial officers are required by the Constitution to apply the Constitution and the law impartially and without fear, favor, or prejudice. Their oath of office requires them to administer justice to all persons alike without fear, favor, or prejudice, in accordance with the Constitution and the law. And the requirement of impartiality is also implicit. If not explicit, in Section 34 of the Constitution, which guarantees the right to have disputes decided in a fair public hearing before a court, where appropriate, another independent and impartial tribunal or forum. This presumption, therefore, flows directly from the Constitution. Footnotes omitted, close quotes. In Non-Tutuzelo Portia Sizani versus Mpofu, NO, and the Director of Public Prosecutions, Eastern Cape, it's an unreported case number 642 of 2017, delivered on the 12th of December 2017. Dealing with the same case of Bennett, Pickering J, dealing with paragraphs 32 to 34 thereof, said the following, I quote, "The court held that it must be assumed that through their training and experience, judicial officers have the ability to carry out their oath of office, to disabuse their minds of any irrelevant personal belief and predispositions. The effect of this presumption of impartiality is that a judicial officer will not lightly be presumed to be biased. Mere apprehensiveness on the part of the applicant that the court will be biased, even a strongly and honestly felt anxiety, is not enough," close quotes. I think it aimed, in the circumstances of this case and the application for recusal, to refer to what is generally accepted conduct in treating witnesses who come to court to give evidence. S versus Azov was an appeal wherein the court was dealing with an entrapment of an appellant. In my view, the conduct dealt with by that court is similar to what transpired here. The court was specifically invited to deal with the treatment of witnesses who gave evidence. Snyman said the following, I quote, "I think it must be clear to him and perhaps to others that witnesses who come into court, be they police witnesses or any other kind of witnesses, are entitled to the ordinary courtesy one extends to decent people. Witnesses who give evidence are assisting the court in arriving at the truth and in carrying out the administration of justice. No cross-examiner is entitled to insult a witness or to treat him in the manner in which these witnesses were treated, without there being a very good reason for it. Witnesses must be treated with courtesy and respect. They are doing a public duty in coming to court. That must be borne in mind by both cross-examiners and the presiding officers. It was clear the duty of the magistrate here it was clearly the duty of the magistrate here to protect these witnesses. I do not wish to be understood to say that a witness may be attacked, but before you can attack a witness, you must at least lay a foundation to the satisfaction of the presiding officer that you have grounds for attacking the witness. Otherwise must be treated with respect and with the same courtesy that you would extend to a man civilized, to a man in a civilized society. One is not rude to people when you speak to them during ordinary social intercourse. So why should it be different in a court of law? Have this cross-examiner really shocked me in regard to the manner in which he treated these respectable men? He starts off by attacking them without any reason. He seems to assume that they are dishonest people and that he is entitled to attack and insult them. When the magistrate intervenes to protect them, he does not hesitate to attack the magistrate. I cannot find any justification for this conduct, and I think the magistrate's strictures of him were fully justified. Close quotes. Analysis in this case. An analysis of the avowed facts which led the applicants to form the purported apprehension is necessary. The avowed facts reveal that in essence there are four grounds, namely, A, I had made up my mind about the credibility of Ms. Zondi, mete out justice for her, accepted the truth of her version without hearing all the evidence or argument, and convicting and sentencing the two applicants. I had decided that Ms. Zondi is a crusade for justice, and I'm sympathetic, partisan, and allied to her crusade. C, I am biased in favor of Ms. Zondi and the prosecution, sympathetic, partisan, and aligned with her. I am and will not be impartial. D, I am prejudiced against the two applicants. A proper consideration of the grounds relied upon by the applicants reveal that the court is not dealing with a mere apprehension of bias, but actual bias as a matter of fact. Actual bias is different from an apprehension. It has been held that actual bias means the judge approaches, quote, the issues with a mind that was in fact prejudiced and not open to conviction. This occurs when the decision maker has prejudiced the case, the decision maker has prejudged the case so as to be unable or unwilling to decide it impartially. Close quotes. I shall first deal with the submission by Mr. Doberman from the bar. It is true that I did mention that, I quote, it is tried the accused should be allowed to prove their innocence, close quotes. This statement must be read in the correct context. When the matter started on 22nd October 2018, as already alluded to, Mr. Doberman made a lengthy submission that his clients were harassed by people who had gathered outside to apparently support the alleged victims in the matter. That issue had nothing to do with the matter before me. Hence, at the end of his address, he did not ask for an order. He merely informed the court that he was merely placing that on record. I thereafter made the following comments pursuant thereto. I am not privy to what happened or to the circumstances leading to the throwing of the water and all those things. I am not privy to that, and I cannot pronounce on it because I was not there, and even if I wanted to, I would have to still hear the person who is an aggressor or apparently poured water over somebody else before I can make a ruling. It is tried that the accused should receive a fair trial. It is tried that they should be allowed to do their best to prove themselves innocent. Then what I need to say in respect of the third aspect is that counsel should approach me in chambers so that we can map a way forward. We conduct whatever we have to conduct so that we secure that the accused should be in court. They should be protected in court. They should be protected when they are coming to court. They should be protected when they are coming to court and should be protected when they leave court. In respect of the aspect of the family members, I think we will trash it. I think you will trash it out as well, because I don't have the powers. I don't know how the seating arrangement is made here. I know for a fact that this courtroom is very small to accommodate everybody else. I do not know the logistics, therefore, I can't comment on how they are supposed to be in court, how they are supposed to be accommodated, but when it comes to the accused, I have a say, close quotes. Those are my words. Obviously, in the excerpt quoted above, I was not referring to the current applicants and their co-accused in that context. I was referring to those who were attacking Mr. Doberman and Mrs. Omotoso as he submitted that she was drenched in water. The simple thing I meant by that is that those who assaulted Mr. Doberman and Mrs. Omotoso should be given an opportunity to state their version, to vindicate their innocence. I went to an extent of saying that saying those complaining should go and report to the police and obtain an interdict. I even referred to the Audi alteram partem rule. It is therefore inconceivable and disingenuous to assume that I was referring to the applicants and co-accused before court. It is basic tenet of our criminal justice system that an accused person is presumed innocent until proven guilty. I would not, as stated in the preceding paragraph, stress the constitutional rights of those who are accused of having committed an assault, and in the same sentence allege that the applicants must prove their innocence. The apprehension of the reasonable men in the position of the applicants must be assessed in the light of the true facts as they emerge in the matter. Now coming to the submissions made by the applicant. It is legally correct that a complainant in a sexual offense, as in this instance, testify on behalf of the state, not herself. Hence, a complainant in a rape case cannot be allowed to withdraw a case against her perpetrator. This is only why Snyman says, I quote, witnesses are doing a public duty in coming to court, close quotes. It boggles the mind to state the obvious, what exactly in that statement that presupposes or creates a perception of bias on my part. Crusader is defined in Oxford Dictionary as a fighter in the medieval crusade, as a person who campaigns vigorously for political, social, or religious change. A campaigner. I'm unable to find that she was vigorously campaigning for justice in the evidence so far. Nothing from what I said suggests that. She is merely before court to testify that justice be done. Lest I am being misinterpreted again, justice is meted out where there is a conviction or an acquittal. Justice is not meant for complainants only. It is as it is insinuated in this ground, it is for the accused persons as well. Therefore, the phrase that it is about justice includes the accused. Mr. Doberman argued as follows, I quote, and to say to a witness in terms your coming to court is not about yourself, it about the interest of justice, presupposes of necessity that the witness is here to tell the truth and has been telling the truth. Clearly that must be the case, because a witness who comes to court to tell lies and mislead the court cannot be here to do so in the interest of justice. Quite clearly, my lord, I close quotes. I'm taken aback by this argument. It has no factual basis whatsoever. The other perception of bias by the applicants is that I overtly sympathetic towards Ms. Zondi. I was overly sympathetic towards Ms. Zondi and her cause. Mr. Doberman repeated this in his oral argument, alleging that, I quote, I openly aligned myself with her cause and that it is not my duty to console witnesses and that it is somebody else's duty, close quotes. I am astonished by this argument. There is nothing which suggests that I was consoling Ms. Zondi. I do not know what Mrs. Zondi's cause is that is spoken about. Ms. Zondi has not finished with her evidence. I do not know what is going to become of the rest of her cross-examination for me to be perceived to have aligned with her cause at this stage. The applicant's testimony is that I have openly identified and aligned myself with Ms. Zondi and her cause again. I reiterate that I do not know her cause. All I know is that she has given evidence about what allegedly occurred to her. I have not pronounced on her evidence, and it is too early for me to even formulate an opinion in my mind because I have not heard the version of the accused, let alone their evidence if they decide to tender it. It is ridiculous in the extreme to even perceive that I have accepted Ms. Zondi's version as true and correct. As alluded to, how would I do so without the version to compare it with? Or there is not even to compare it because there's not even a shred of a version of the accused put to Ms. Zondi. It is only an unreasonable person who would formulate a perception that I have already convicted and sentenced the applicants from what I have said to Ms. Zondi. The applicants further submit that I am biased in favor of the state and Ms. Zondi while prejudiced against them. There is not even an iota of evidence to even give the applicants an inclination that I had taken sides in this matter. There is nothing leaning towards that in what I have said to the witness. No reasonable person would allege actual bias on these facts. With respect, the perception that applicants shall not receive a fair trial and I shall not be partial is baseless. That cannot be inferred from what I said to the witness, nor can a reasonable person be drawn, nor a reasonable perception be drawn from the circumstances under which the statement was made. Taken singularly and also globally, the grounds for my recusal are spurious. As stated in SAFU judgment above, the test applicable in this matter is a twofold objective element, or what tend to be known as double reasonable requirement. In South Africa, Commercial Catering and Allied Workers Union and others versus Ivan and Johnson Limited, Seafoods Division, Fish Processing. It's 2000 volume 3, 705 CC, paragraph 16. Cameron AJ, as he then was, said of this requirement, I quote, "The double unreasonableness requirement also highlights the fact that mere apprehensiveness on the part of a litigant that a judge will be biased, even a strongly and honestly felt anxiety, is not enough. The court must carefully scrutinize the apprehension to determine whether it is to be regarded as reasonable. In adjudging this, the court superimposes a nominative assessment of the litigant's anxieties. It attributes to the litigant's apprehension a legal value, thereby decide whether it is such that it should be countenanced in law," close quotes. Having applied this and other principles in this case, I am of the view that a reasonable person in the position of the applicants would not apprehend bias from the utterances or the common courtesy wishing of Ms. Zondi good luck in her examination. I further find the apprehension itself is unreasonable. It is not about the subjective feelings of the applicants. The applicants have failed even to prove objective facts which led them to apprehend that I am biased. The applicants have to establish that a reasonable, objective, and informed person would on the utterance have reasonably apprehended that I am biased and shall not be able to bring an impartial mind to bear in adjudication of this matter. They have dismally failed to do that. These are my reasons.
As a court, Mrs. Manda.
Sorry, my Lord. I didn't realize you were waiting for Mrs. Ozam. My Lord, before I address you, can I give you a copy of a judgment of Huisin J?
You trusted me in connection with what, Mr. Price?
It is dealing with the recusal. We are bringing an application for leave to appeal to SA, my Lord. I think it will be quite useful because I will be quoting liberally from it, my Lord. It's a recent judgment.
So you will be arguing right away?
Yes, my Lord.
Where's the application, by the way?
It has been filed. If you haven't got it, then it's someone else's turn to be accused.
Section 16(1). Yeah.
Yes.
Thank you, Mr.
Thank you, my Lord. My Lord, first and foremost, let me indicate, as I've indicated to you in chambers, this is always a very difficult application. Yes. Because it tends to become personal, or to appear to be personal. But your Lordship knows it's not personal. I'm briefed to do a job, and I'm going to do the best I can, my Lord. My Lord, may I first begin by indicating that this is actually a two-pronged application for leave to appeal. Your Lordship has now given reasons for the recusal. But the other part of it, my Lord, if you look at the
quashing of charges.
Yes, the quashing of charges. Your Lordship also did not give reasons there. So I'm going to ask you...
May I ask in respect of that one? I don't want to interrupt.
Sir, of course, certainly, my Lord.
I think you know what type of order I issued there. I'm not sure whether you issued an order to the effect that I shall reserve the reasons and hand them all, either during the trial or at a later stage.
Yes.
Have they been sought?
No, my Lord, but the problem is, if I may just address you on that point, the problem is that both your application, both your decision not to quash the charges and your decision not to recuse yourself are final judgments. They're not interlocutory.
I'm with you.
And when you're dealing with final judgments, you must give reasons, my Lord. And the purpose of giving reasons, particularly in that application to quash the charges, being an in limine application, is particularly important, my Lord, because that is the crux of the case. That's where the case begins. And my respectful submission, I would have asked your Lordship to give me reasons.
Yes.
Because it is...
Because what occurred thereafter was that they decided to exercise another right, and then I enter a plea of not guilty in terms of Section 109.
Yes. Yes,
so there was no indication that there was an appeal.
No, there wasn't, my Lord, but this is crucial. I'm going to try and argue these two together so we don't waste time individualizing these two. My argument, my Lord, is that when we consider the recusal application, we must also look at this application. And my submission, my Lord, is, and I say this with the greatest of respect, my submission is that the refusal to quash the charges has got the ability in itself to persuade a court, another court in this instance, that in itself is an indication of an apprehension of bias. My submission, my Lord, I make very simply that there's nothing more important in a criminal case than the charge sheet, because that's where it all starts. And the Constitution of the Republic of South Africa makes that very clear in Section 35(1)(a) and following, that you must get a clear and concise charge sheet. And my Lord,
may I just interrupt?
Certainly, of course,
yes,
of course,
Mr. Price. I think, let me raise this from the onset. I think the notes of the notes of application for leave to appeal is wrong.
It's wrong.
Yes.
This one is wrong.
Yes. In the sense that you can you check the section? Do you have the Superior Court's Act?
I don't have it here, my Lord, but I've looked at it over and over. It says 16(1)(a) subsection 1 says any decision by a single judge.
That's most probably yours is not up to date. I don't know.
Well, it's the very latest. It's the very latest that I've.
The very latest section, which deals actually the section which you've quoted, doesn't say what you say.
Are you talking about section 16(1)?
16(1). Yeah, I'm talking about 16(1)(a).
Roman 1.
Roman 1. Yes, because if you check the commentary thereof, it says an appeal. This does not include an appeal in a matter regulated in terms of Criminal Procedure Act 51 of 77, yes, or in terms of any criminal procedure law. Yes. And then it refers to the definition of this section. The definition says, if I may, where's this?
Where is your Lordship reading from?
I'm reading from the notes.
Note up in which book?
No. I'm reading from the from Jones and Buckle.
Is that Erasmus? Oh, Jones and Buckle.
It's in fact it's Van Longen and
yes.
the Supreme Court Act, second edition Van Longen.
There are a lot of them, my lord. That's why I was just saying, trying to find out which one you were reading from.
And the appeal says Chapter 5 does not include an appeal in a matter regulated in terms of the Criminal Procedure Act 51 of 1977 and in terms of any other criminal procedural law.
Yeah. We're not bringing this application in terms of the Criminal Procedure Act.
What are you bringing it in
terms of Section 16? No. This is not. The Criminal Procedure Act, my lord, deals with appeals that have been completed.
Yes.
This is not a completed case.
Okay. Let me now that we define.
You can take your lordship can take it for granted that I have made inquiries because this is something quite new.
Yes.
And I have spoken to the correspondent attorneys, and I'm told this is the route to go. But I do understand what your lordship is saying. But I've had a look at Section 319 and 316 of the Criminal Procedure Act, and they deal with matters that have been completed. 316 that deals with appeals, and 3165 deals with where you want to put new evidence.
In my understanding, 316 is the most relevant to.
Yes, but 316 is not relevant here.
Yes.
It's not relevant here because we're still in the middle of the trial, my lord. And 319 is the one where they reserve points of law. Both of these are points of law.
Okay.
But 319 is not applicable, my lord, because that point of law is dealt with by the Court of Appeal at the end of the case, which is why they are reserved. I do understand, though, your lordship. I had to take a good look through all of this. But may I then proceed, my lord?
Yes, you may proceed, Mr.
My lord, the most important thing that has changed from, let's call it the bad old days, to where we are now, is the respect that our courts, and in particular brought about by our Constitution, that our courts have for the presumption of innocence. You wouldn't say that when you look at the press and the social media and all of that, but this court, I know, respects the presumption of innocence. To assist an accused person, my lord, and to ensure that there's at least some equality of arms. In other words, there's some measure of equality between ourselves and the state. The state have got a police force to help them, we don't. The Constitution steps in and says things like the charge sheet must set out in detail, not only the Constitution but also the Criminal Procedure Act, in detail, time, place and manner of offence. Now, my lord, this is one, with all due respect, and I'll say this with great respect, this is one of the worst charge sheets I've ever seen. Because this charge sheet says, in places, in 2010, at or near Israel. I've never been to Israel, but it's not a blob, it's a country. I was raped. It's got to be much more specific, my lord. It's got to be much more specific, both as to time. Israel is a big place. And as I think your lordship, or maybe Mr. Doberman did point out, Ms. Zondi, look at her passport. Her passport will show when she was in Israel. And she couldn't have been there too long, so you could narrow it down considerably, my lord. Which, of course, this wasn't done. Mr. Doberman, in his cross-examination, even managed to narrow down the time period to a certain degree. But, my lord, the real importance of a proper and thorough charge sheet is to enable you to prepare and to plead. It enables you to challenge the state's case, my lord. And this is a formidable state case that Mr. Doberman has to challenge, my lord. There are 21 witnesses. We don't want a situation of conviction by number. You normally wouldn't be convicted if there were 2, but there are 21, so good night, sweet prince. We don't want that. So Mr. Doberman must be assisted by a proper, thorough and really more detailed charge sheet, my lord. I'm certainly not pointing fingers at your lordship. I'm pointing fingers at the state. This is a bad charge sheet. I think we must carry on, my lord. Then these cameras will turn themselves off. They won't know what we're talking about. My lord, you know the alibi is so important. It's so important, my lord. And Mr. Doberman, yes, the defense
in respect of the
in respect of a lot of these people, my lord. Now, for Mr. Doberman, and anyone for that matter, and Mr. Doberman has really done a sterling job in my view. For Mr. Doberman to have to challenge these witnesses, and my lord, we all know how it works. Cheryl Zondi made 2 statements, I gather, one to the police and one that she wrote to herself. Now, from what I gather, my lord, and I'm not addressing you on the merits, rest assured, she appears to have deviated in the sense that in the first statements there was no suggestion of vaginal penetration or attempted vaginal penetration. It only came out in her evidence in chief. Now, I'm not being critical of that. I'm just saying this is something Mr. Doberman must deal with. Now, if that had been, if a proper and thorough consultation had been done, and I don't know, I can't accuse my learned friends of not doing one. you then have to ask her, look, you say this is what happened to you, I was abused. Give us some details. What was the abuse? And if I can just, on one very important point, my Lord, and I think it's a particularly important point, and not because of the people around here that know what's going on, but because of the absolute nonsense that is spoken outside this court. Mr. Doberman being criticised for asking how far was the penetration. You would swear that he's just shot the Pope, the way they carried on. My Lord, that question may not have been asked in the best possible way. Yes, but it was necessary, my Lord, because it's all about penetration. And it's all about labia majorum, labia minora, etc., to determine, in fact, whether your Lordship at the end of the day can find attempted rape or, in fact, rape. So it was a very necessary question, perhaps a little crassly asked, but it was a very important question. Now, remaining on the charge sheet, my Lord, that alone, I think, we need to have the view of the highest court, my Lord. We need to hear what the Supreme Court of Appeal might say. Because, my Lord, there's so many things the Supreme Court of Appeal could say. They may say what your Lordship suggests. They say, cross-examine. Get your evidence from when it happened through cross-examination. But then you're ignoring the Constitution that says you're entitled to a proper, decisive and thorough charge sheet. So they're not likely to go that route. But they may, my Lord, refer the matter back to this court and then make an order that the prosecution re-examine or reconsult with all their witnesses and get better details. That may be, and your Lordship would have to obviously preside over that. I don't know what they're going to do, my Lord, but it's something so crucial.
So because it's silent, your Lordship of Appeal is silent on whether you seek leave to the SAA or to...
It is so, my Lord.
The full bench of this court.
No, my submission, my Lord, is that the highest court of appeal in this country needs to deal with it. My Lord, if your Lordship grants us leave to appeal, obviously we want to waste as little time as possible. And my learned friend and I will get together. It's normally 30 days for me, 30 days for him, 15 days. But there's nothing preventing us from saying, we'll get it in 10 days, he does 10 days, we waive our 5 days. We can have this thing up there in no time, my Lord. And I know it's not fair to the complainants that are waiting to testify. It's not fair to Cyril Zondi, who will have to return, but it's also not fair to the accused as well. So, my Lord, let us have another view. Let's have another opinion. Let's see what the SCA says about this. Because if you look at all the books, Hemstra's book, the Toy and Pies, all of them, they're not good on this. Well, let me put it differently. There's not much case law on this.
There's none.
In fact, there's very little. So it's very difficult for you and it's very difficult for us. So what we do, my Lord, we argue on our feelings, what we submit should be there. And that is why we're going to the alibi. Now, I noticed in the evidence of Cyril Zondi, my Lord, Mr. Doberman raised an alibi. Because he was able to raise an alibi because he pinned her down to a certain period of time. Now, if Mr. Doberman, through cross-examination, can narrow the period as much as he did, then I think a little bit of extra consultation, perhaps get even more senior advocacy in for the state. I'm not pointing fingers. These are very competent people. But, you know, this is a tough case, my Lord. It's a very, very tough case. Not only for us, but for yourself as well. And I think it would be so much easier for Mr. Doberman to be able to then conduct his cross-examination if he's got more details, my Lord. And of course, that will shorten the cross-examination. Because Mr. Doberman is forced, because of the vagueness of the charges, to ask questions that you normally wouldn't need to ask if you had more specific details. So I would really request your Lordship to grant us leave on that. My Lord, on the recusal, there are a number of things that your Lordship made, comments made that you made that I agree with. It's a tough thing to ask anyone to recuse themselves. And it's not, the interesting thing is it doesn't matter where you bring a recusal application. In reviews in the lower courts, they tend to like you to bring them rather earlier than later. But you'll see in the judgment I gave you that where the impartiality or the alleged impartiality of a presiding officer is concerned, my Lord, if you look at page 4, paragraph 12, the general restraint upon a court exercising its review jurisdiction in unterminated proceedings does not apply in circumstances where the impartiality of the judicial officer is impugned. So it doesn't really matter at what point in time this application for recusal was brought. It may matter in the sense that...
From which paragraph?
My Lord, it's page 4?
Page 4.
Paragraph 12.
You were involved in this matter?
Yes, I was involved.
Yes.
One of the few I've won, my Lord.
Yes. One of the few you've won?
We've had a bad run, my Lord. We've had a bad run. By the way, I won 2 today, so I mustn't complain too much. My Lord, I've marked in green. I'm sure it's come through on your copy, has it not?
Yes, yeah, it has.
That is what I'm relying on. Then, my Lord, if I could turn
the marked portions of.
Yes, the marked portions. If
12, 18, and 14.
Yes, my Lord.
Yes.
If you turn over the page, these are judgments Lagranzi, Roberts, and there are a few others later. Your Lordship's judgment, paragraph 21 that you referred to, the President of the Republic of South Africa.
Yes.
But let me just read why I submit that we should give leave. I want to make one thing very clear, my Lord. I'm not for 1 second suggesting that you are biased. Not at all. I'm not for 1 second suggesting that you're malicious. I know you're not malicious from my experience with you. But that is not the test, my Lord. That is unfortunately not the test. Yeah. If you see in Lagranzi's case, the SCA says, what the law requires is not only that a judicial officer must conduct the trial open.
You're on which page?
Page 5, my Lord, paragraph 14.
Page 5, paragraph 14.
Yeah. What the law requires is not only that a judicial officer must conduct the trial open-mindedly, impartially, and fairly. Now, I don't have a problem with that at this point in time, but that such conduct, and here's the secret, my Lord, must be manifest to all those who are concerned in the trial and its outcome, especially the accused. Now, the reason why I make that so important, my Lord, is because you may say something completely innocently. Let's take, for example, the comment about the accused must get an opportunity to prove their innocence. Now, that in all probability, you may have said it in complete innocence. But that is not what's important, my Lord. What's important is how does the accused or the reasonable people in the position of the accused see it. This is not an application, my Lord, for an leave to appeal based on your Lordship's bias. We are not for 1 second suggesting, and certainly I won't be part of a suggestion that you are biased. It's simply an unfortunate choice of words, which we've been guilty of ourselves. What does it mean to the obvious person? Now, I can understand. Let's go to Cheryl Zondi. I can understand that your comment that, you didn't come here for yourself, you come here for justice. I can understand that your further comment that leave this to us was intended as being nice to you, if I could put it in as crass a way as I can. But, my Lord, what does it mean to the person in the position of the accused? It means something totally different. All I'm saying is it's possible from that wording, my Lord, for a person other than yourself, and even accepting that your Lordship didn't mean it in any particularly bad way, it may create the impression to the reasonable accused. Now we're dealing with an accused, my Lord. We're not dealing with a lawyer or a paralegal or something like that. To believe, why is he making these comments to this particular witness? It goes further, my Lord. Your Lordships appeared, and I'm saying this again, my Lord, with the utmost respect, that you treated Ms. Zondi very cozily. Your Lordship repeatedly said to you, are you all right? Would you like to adjourn? Are you tired? Would you like to sit? Do you need some time? Now, my Lord, again, taking in isolation those comments.
Were they not set in context?
Well, if you read them in context, it's the repetitive of them that worries me. I do understand that your Lordship was perhaps trying to make the witness in a very difficult situation. She's sitting there testifying, and it's very difficult. But we must remember, sadly, my Lord, and I think she was wrong, it was her choice to testify in open court. I think she should have testified in camera, but that's the point. Now, yes, it's the accused and the two ladies with, and they're looking at this, and they're thinking, why are you mollycoddling this witness? Why are you carrying her? Why are you so nice to her? It may be because your Lordship's a nice person. It may well be. But that's not how it's seen by someone there, my Lord. Now, my Lord, if we go any further, then I'm not going to read everything in here. I know that your Lordship will read it. But
in fact, I read this judgment.
Yes, my Lord. I think it's very important, though, to say what is said in paragraph 15. It must be, paragraph 15 on page 5. It must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial. Right. Now, even if we accept, my Lord, that you're an impartial judge, that again is not the test. That's the basic principle. Then they go further, they say fairness and impartiality must be both subjectively present, and I accept in your mind is subjectively present, my Lord, and objectively demonstrated to the informed and reasonable observer. There's the problem, objectively demonstrated. Your Lordship might have acted subjectively in a way that really doesn't require your Lordship to even consider a recusal, but from an objective point of view, to people watching your Lordship, another impression might have been created. And sadly, my Lord, That is the only test that the accused needs to overcome. It's not bias, my lord, it's perceived bias. And there is also a case law that says, when in doubt, get out. My lord, then, if I can take you to the bottom of page 6, and the last 3 lines, my lord, of the President of the Republic of South Africa, Salford judgment.
That's page 6, yes.
Page 6 at the bottom, my lord. At the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial. And a judicial officer should not hesitate to recuse herself or himself. If there are reasonable grounds on the part of the litigant, let me stress this, on the part of the litigant, not on the part of Terry Price or the part of Peter Doman, on the part of the litigant, for apprehending that the judicial officer, for whatever reasons, and that's another important issue, was not or will not be impartial. My lord, if we go over the page to McLaughlin, page 7, I'm going to look at 24, my lord, because I think it's important to state that 23, if your lordship grants leave to appeal, we've already indicated we'll shorten the times and get this thing up there as soon as possible. If your lordship refuses both applications, no, please, my lord, this is not a threat. I'm just telling you what the legal position is. We cannot continue. The trial cannot continue while we go to the SCA on petition. And that's what they say here, my lord. Paragraph 24. Paragraph 23. The disqualification is so complete that continuing to preside after recusal, and these are very important words, my lord, should have occurred. So this isn't a court of appeal looking and saying that gentleman or that lady over there should have recused themselves. Should have occurred, renders the further proceedings a nullity. So whatever we do here, my lord, leave granted where we can try and speed it up, or leave not granted where we will also, obviously, my lord, try and speed it up. The matter cannot continue. I think it's essential that we get it to carry on as soon as possible, my lord, and I've indicated to you we can cut the times in agreement between the parties. Now, my lord, this particular case is a very interesting case, the one I'm reading from. The magistrate called Mr. Gribeno, who you know, and said to him, do you know what the prosecutor in this case did? It's not just before he gave his judgment. He said to me, you better hurry up and give judgment because the accused is still stealing from the complainant. So, I mean, that's not what we've got here. I mean, that's over the top. I'm sure your lordship wouldn't have hesitated to taken steps in those circumstances. But what happens then, he says, phone me, bring an application so that I accuse myself, which we did. Then he refused. But what he said, my lord, and that is something I want to stress, we must not do here. He said, I am a fair-minded person. I'm not biased or anything like that. That is not the test, my lord. Sadly. So even as your lordship sits there, even if I, my lord, subjectively speaking, believe that your lordship is not partial, that's not the test. The test is what does the reasonable person in the position of the accused say. My lord, if I can then just summarize, I've taken a number of issues out of the record that I submit individually may not mean too much, but put together and looked at globally or holistically do mean something. My lord, one thing particularly perturbed me, and that is at one point in time Mr. Doberman, cross-examining Ms. Zondi, said to her, well, got her to concede that the every other day rape she was talking about occurred in a particular period of time. And then once he'd got her to confirm it happened then and it happened every other day, then Mr. Doberman took out an air ticket. Now it was quite obvious why he's taking out an air ticket. He's going to reveal an alibi. But he was able to there, my lord, because the period of time was narrow, which we don't have in the charge sheet. And then before Mr. Doberman went further, Ms. Zondi then said, oh, is that the trip to America? And Mr. Doberman said yes. And then your lordship made a comment that worried me a little.
That when I said it was, you recognize that it was before the
ticket
was...
Yes.
Yeah. Because the record, yes, or not, I don't have to state the reason why I asked that.
Your lordship may
yes,
have,
I remember I asked that. Yes,
your lordship may have had a very good reason for asking it from your perspective. But my lord, it doesn't read well. Because the way it reads is, forget about you. You haven't really caught her out because she said, I'm not saying that's what is a fact, my lord. I'm saying that's the apprehension. Because that is a crucial point in the credibility of evidence, my lord. If your lordship had a fine, and I've read the record a bit, I'm not going to go into detail, I'm not going to address some of it, but if your lordship had to find that in a period of time that she says, without fear of contradiction, the pastor, accused number one, raped her, that the pastor was in America, my lord, that is a massive blow to her credibility. Another part is where she claims it happened at a particular house, and Mr. Doman's documentation that house was not occupied by the pastor but by other people. That, my lord, is devastating to her credibility. So all I'm saying, my lord, in a case with as much emotion as we have here, and it's emotional, my lord, for all of us, your lordship included, we've got to be very careful, very, very careful, all of us, my lord, how we put things, how we say things. So I'm submitting, my lord, that from a holistic point of view and purely from an apprehension or perception of bias, perception, people in the position of the accused may well believe that your lordship might be biased. And that is enough, my lord, for you to grant leave to appeal. Now, my lord, the Court of Appeal in Bloemfontein, should you grant leave, may turn around and give us a thorough hiding on this. They can turn around and say that His Lordship, Mr. Justice Makula, didn't say anything wrong. Those words you've taken out of context, you shouldn't have argued that way, you don't have merits, but let them say it, my lord. Because then you stand completely clear and the matter can continue, if, of course, nothing happens on the first application. My lord, all I'm saying is that every one of us can make a mistake. And every one of us does make mistakes, my lord. All the time, every day. I think the crucial thing here, my lord, is to see, and I know it's tough because your lordship is sitting in a very high position. It's tough. Is to say, you know what, I might have got it wrong. But let's see what the SCA says about it. Because the SCA may come out 100% in your favour, my lord. And that will then mean that this case continues as it would have been continued. All I'm saying, my lord, is what happens if we get to the SCA, either by way of petition or if your lordship grants us leave, and the SCA says the charge sheet is an abomination and all based on a perception and only a perception of bias. Your lordship should have done what was suggested in a reported case. When in doubt, walk out. Now, I'm asking your lordship, and I'm asking your lordship in the spirit of one of the best legal systems in the world. This country has got an incredible legal system based on probably the most proactive constitution in the world. In the interest of justice, my lord, not pointing fingers at you or the prosecution, I'm requesting you humbly, my lord, to grant us leave to appeal to SCA. And I promise you that if your lordship does so, we will cut our days down and we will get this thing up there as soon as possible. Can I have a second, my lord?
Yes, you can.
Thank you, my lord. That's all.
Thank you, Mr. Vice. Mr. Ndela.
As the court pleases, my lord. My lord, I'm going to go straight to the merits of his allegation without going to the procedure as to how this was brought. Can I just... Lord, may I first address on the first round, that is the ground of quashing of the charges. I don't agree with my friend. First, on that point, that this is an appealable ruling. And my lord, on its nature, that ruling is not appealable, since it does not have the final decision. I like the way my lord, that the...
You mean the question of charges?
The question of charges. That is the refusal to quash the charge sheet has not, does not have the effect of a final ruling. The court can change its mind anytime during that trial. Therefore, it is not appealable. And if I can draw the court's attention as to how the court has been dealing with the judgment that are either locality. I'm gonna draw the court's attention to this judgment in my lord. It's a Mayor's Board decision.
What?
Let me just get it in for my lord. Is okay. It is. My lord is the Mayor's Board.
Mayor's Board.
Mayor's Board, yes.
Are you going to provide me with the copy or?
Mayor's Board. I got it, my lord. Mayor's Board and Tiger Oats Limited. Its acceleration, my lord, is for my learned friends is 2002, volume 3, all SA reports. At page 593 is an appellate division, and the paragraph reading from is paragraph 4, where the court was defining the non-appealable decision.
The
non-appealable decision.
Yes.
That is the ruling by the court. The court was quoting from another decision with approval. That judgment that this court was quoting from was by Judge of Appeal Harams in the Zwini versus the Minister of Law and Order. The court held, generally speaking, a non-appealable decision that or ruling is a decision which is not final, because the court of the first instance is not entitled to alter it. Sorry, my lord. Because the court of the first instance is entitled to alter it, nor derivative of the rights of the parties, nor has the effect of disposing of at least a substantial a portion of the relief claimed in the main proceedings. Therefore, it is my submission that the decision to refuse my lord to quash those charges has not an effect of a final ruling. And also, our law in this regard has a provision that, I think my lord is section in the CPA that the evidence is 88, that the evidence can also show the charge sheet. I think it is in anticipation of that this ruling the court gave under the question of the charges is not final. Therefore, it is not appealable. And I think my learned friend, Dr. Benin, was aware of the fact. Hence, he did not pursue it further after the court gave that ruling. And it is my submission that now to couple it with this application for the buyers, it was, I think, the ploy to delay these proceedings, not to proceed further. Therefore, it is my humble assumption that this decision is not applicable, my lord. And if I can go further and try to respond on what my learned friend, Mr. Advocate Price, has addressed to convince the court that the court should give them the leave to appeal to the SA court. He mentioned that there are charges that emanate from Israel, and it was not clear as to where in Israel. That was their basis of making their submission stronger. I thought if Manal Fed can look at the report from the beginning, all those offenses that were committed outside this country, they were successfully objected to. Therefore, I don't know why now they are bringing it now at this stage as the authorization. It is not a canvas. Actually, number one, allegedly committing these offenses outside this country. Therefore, that submission that in Israel they don't know which place has no bearing. And also, my lord, also on at that point, it is going to be so academic, because if you look at the charge sheet, it enlists the places where these on diverse occasions occur. It does not change, even if we can take out maybe the other towns, but that offense is still there. So the relief sought is academic to me. Therefore, my Lord, it is on those grounds that I submit that this court should not entertain this frivolous application. Coming to the second ground, the ground of bias. My Lord, there is a very good inquiry that I got from another judgment of the Constitutional Court when dealing with the bias allegation, or maybe I can put it as an allegation or a submission. That is the case in State versus Eberson. My Lord, the citation is 2005, Volume 1, SA at page 171. My Lord, is a Constitutional Court.
Yes, I do have a copy of the judgment. Yes, you can have one.
Okay, my Lord. I'm going to refer the court to paragraph 33. That's one. It's set as to how the court should deal with the bias inquiry. There are two stages according to the court in this paragraph. The first one is the definition of what is paragraph 33, my Lord.
33?
Yes, my Lord. The first stage is a determination of what the facts are. And the second stage is what a reasonable litigant would think in the circumstances. Therefore, that's where the test is. It is not what the applicant or the accused think. It's a reasonable litigant. That's why in the case of the Sarfu, it is an informed person. And now this reason has come up clearly that he should be a reasonable litigant. The accused is not a litigant. Therefore, it is on those grounds that I submit that.
Also, is he not a litigant?
Of course he's a litigant.
Accused not, how sure are the accused not litigants?
No, from what now from his submissions, they show that he is only looking at his interests, not objectively. That is why I am submitting that his application is not consistent with the law in this regard. He is talking from his point of view, not objectively. Hence, I'm saying that in interpreting what the court said like that shows that he is not objective as we think. Therefore, the tester is a reasonable litigant. Somebody will look this from the other view, not only from his point of view. And it is on that ground that I submit that my legal friend and the applicants have failed to come up with a ground before this court that there was indeed a bias on the part of this court. Therefore, it is on that ground that no other court can find some bias on the part of this court. But there's one case I would like also to just bring to the attention of the court to understand why I'm making that submission. I've got a judgment of Sega and Smith. And it is important that I can briefly just give...
What is the citation?
Also, my Lord. The citation in this case is 2001, my Lord, Volume 3, all essay report, page 401. It's also my Lord, the appellate division judgment. What is important, why I'm quoting that case, my Lord, is if the court can look as to what was the issue in that case, the court would understand that what now it is facing in this application is very much weak when it considers what the court view was facing in this and was dismissed. In this case, my Lord, what the magistrate said Just a moment, I'll just get to this part. It didn't mark. Just a moment, my lord, I've lost this. I didn't mark it. It was. My lord. Lord is in paragraph 11 of the judgment. What was a comment about in that judgment was the magistrate said that the applicant's case was a frivolous matter.
A what?
Frivolous matter, and further said that as the case was continuing and the defense was cross-examining the witness, the court had a remark that the learned friend was pleading her as he was doing that cross-examination. That was taken on appeal in the SA. Because of that perceived bias, it was dismissed. And if you look at what your lordship said, is nowhere close to what was happening in the judgment. And my lord, if I can draw also lastly the court's attention to what is required, what is the test of the leave to appeal. In terms of section 17 of the Superior Courts Act, that is 17/1, leave to appeal may be granted if the court is of the opinion that there is a prospect of success on appeal, or there is a compelling reason to hear it. My lord, it is my submission that my legal friends have failed to put that before you, my lord. Therefore, it is on those grounds that I submit that this application should fail as a court pleases, my lord.
Very briefly, my lord, let me just assure your lordship that the accused are litigants. I don't think we need to argue on that one. My lord, I want to refer you to State versus Besson. I would imagine it's the same judgment that my learned friend has just referred you to, but his was 2005 and reported in all South African reports. I've got one that was reported in 2007 in the ordinary criminal reports. Ordinary reports, my lord, not the criminal. So it's the SA. The SA. It's a Concord judgment. I just don't have the page, my lord. I've forgotten the page, but it's 2007, Volume 3, SA. And the only thing I need to inform your lordship about here is this matter came from the SCA to the Concord. And the SCA had found, it was on exactly the same 2 points we're arguing here, the quashing of charges and the recusal. It's that voted Besson case that your lordship will recall many years ago. Now what happened there, the SCA said, since the quashing of charges is a final judgment, they can appeal. But a recusal is not a final judgment, so therefore they could not appeal. But the Constitutional Court found that the SCA were wrong and found that both a quashing of charges and a recusal are final judgments, my lord. And where they are final judgments, and of course your lordship must give evidence, but can give leave to appeal. In effect, they are final judgments. That's the highest court in the country. Thank you, my lord. I have nothing further.
What will be the date on Tuesday?
Tuesday next week?
Yes.
I think it's the 30th, my lord. 30th of October.
Is that so?
Yes, it's the 30th.
30th. It's a Tuesday, my lord?
Yes, it's Tuesday. It's Tuesday.
It's 30th.
As I say, clash of Limkile.
And my lord, can I submit those two judgments I was expecting?
Oh, you were going to give me a copy. Thank you, Mr. Thank you. By the way, the accused would have to be here.
Yes.
Stand up, ladies and gentlemen. Your matter is postponed until Tuesday, the 30th of October 2018 at 11:30.
Court, please.
Accused number 1, you shall remain in custody. Accused number 2 and 3, you shall be out on bail on the same conditions as before. Thank you. Court shall adjourn.
All right. Yeah.
Yeah.